first question that need to be asked is whether everything that can be done in the country is available by way of law. A law which is publicly made. Making laws publicly means making laws with the consent of the people. Consent, of course, everybody would understand is not that everybody has to say yes or vote for it. That there is a public debate and the basic ideas are expressed in the society, so that more or less any law that would be passed within the country is with consent. Now, not to do that is to have a law passed secretly. And how do we know whether the law which is passed secretly is right or wrong, whether it's going to violate our rights or whether it's going to do harm to us? See, the basic principle is this, that what any of us can do to others is limited by one principle, that we cannot harm others. That limitation of the principle applied also to governments. No government can make law to harm the people. So whether it is harmful or not, we should be able to find out by knowing the law. Now, maybe in terms of some of the developed countries, this is taken for so granted that people may ask, why is the need to talk about this? It is because it is not taken for granted in many of the other countries. Now that is the first principle. The other principles are quite simple. First of all, the law should be available to anyone at one point. If he is told that, in terms of this law we are doing this, it should be available for them to see. It is there. In other words, nothing should be left to pure discretion of somebody to say, yes, this is the law and you should abide by that. Now, how ridiculous the things can be, I can give you just by an example which happened just yesterday and which we have, which has become a talking point in Sri Lanka. A lady who is a British lady who seems to be, being influenced by Buddhism, arrived in the airport and she passed through the immigration. But then somebody took her to the police station saying that, you are wearing a tattoo and the tattoo is a picture of Buddha, and this country we don't allow you to do that. And of course, behind this there is other things about bribery and corruption, which always goes with this kind of thing. And then the police took her to the magistrate. Magistrate made an order immediately to deport her from Sri Lanka, and accordingly she was deported. Now the questions are, people are asking, where is this law? Magistrate never asked. The magistrate should have, first thing he should have asked is, you are asking me to do something, where is the law? Now it has become very clear that only person who can ask a foreigner arriving in the country to be deported is the Minister of the Foreign Affairs, and for good reasons. And that the person has a right to challenge. And the challenge will be looked by, if it is looked by one judge, they have a challenge also to higher courts and get it cleared. Now there is no law, and the person can be, as a serious matter as deportation can be done without law. And that is not a surprise, because more serious matters are done without law. For example, the question of forced disappearances. Somebody comes to your house and asks you to come with them, saying that, in half an hour you will come back home or something like that. And then because they show the right authority with their card, so you have to go with them and you never return. Now, where is in the law that a person could be, made to disappear? Where is the government's authority to do that? Nowhere. Not only it is not there, it is contrary to the basic principles on which any law can be made. Because you cannot make law for anything and say, it is a law now, therefore it is legitimate. There are principles which governs the legitimacy of the law. So this is another, basic aspect, that person should be able to, if he is charged or if he is, say, this is the law. Now, there is even a more important principle, which can virtually correct any of these things. That is, the law must be administered finally by courts openly. The both are important. It's by courts and it should be done openly. Even the courts do not have a right to make decisions, in secret. Now, the example that I gave you earlier shows two things. One is that this was done virtual secrecy. We don't know whether she was even taken to the magistrate in the open court. Very often, person is taken in a jeep or something like that. The person is inside the jeep, and he goes with some file to the magistrate and say, this is like that, and the magistrate signs. And that person doesn't know what has taken place. So this is again very important in the context that we are talking. The courts must do things in the open, which also means under the possibility of having representation, that a lawyer on the person's behalf should be able to be there, so that even if the person does not know the law, that the lawyer will know the law, and he can argue these cases. And making things in the public also implies that the judges are bound to give reasons for their judgments. They must say that this is what one party says, this is what the other party says, this according to me is the law that I am applying. In terms of this law, I find this party to be more correct than the other party, and therefore I am making my decisions for following on these grounds. Why should be given in writing? For it to be very clear, this is how this decision was made. Also, to be able to challenge it. You can go to another court, and the other court must be able to see, higher court must be able to say, this is why this judge made this decision, so that if it is wrong, we can correct it. Now, when you don't have this procedure, what happens? Now, there are countries like Cambodia, where the second time the appeal court begins the case from the beginning. All over all the evidence and everything, because how did that man come? All that the appeal court should be able to do is to say what the lower courts did was wrong, and to take the actions to correct that on the basis of record. So public record is very much a part of when we talk about doing things in the public. There should be a public record of decisions. So all these are bound up with administrating the law through courts. Now, why this has become so important is there are several countries around in Asia where the authority that will make a decision will be a minister or even the chief, the executive or some officer. And beyond that, there is no recourse to court. Of course, administration requires various powers for officers to make decisions. But it must be possible to see whether those people acted according to the law. So again, one of the basic principles of rule of law is a person who is making a decision can make such a decision only to the extent that the law authorizes him to do. You can't say, well, I think like this, therefore, officer must say, I am authorized to do the following. And in terms of that authority, I am making this decision, which means that if that authority is not there, then the whole thing is not legal at all. So these are some of the few principles. Of course, this can be elaborated into much more detail. These are some of the more simple principles around which you can judge whether the country is functioning under a system of law, which is also a system of rule of law. Because sometimes there can be law, arbitrarily made law, and the kind of judges who are also just the, administrators on the behalf of the government. The rule of law requires a separation of powers. The person who is a judge must belong to a separate branch of government. Of course, this separation doesn't mean like, you are cut off from other things. But separation means independence. I make this decision not because so-and-so tells me. I am making this decision because according to the legal provisions, according to reason, according to well-considered consideration, I take the responsibility that this is the only rational decision that is possible under the circumstances. If I am wrong, go and challenge it in another court. They will also see whether I did the right thing. I am subject to that. So all these things are today, are not things that can be taken for granted. The question has come up even to the extent whether a government can make only lawful decisions. Today there is an idea, is lawful or not, doesn't matter. So if you are living in that situation, you don't have the protection of your liberty. This is a central issue. Central issue of the rule of law is the protection of the liberty of the individual. So the law in its operation will make sure that it protects the liberty of the individual. If that liberty is not there, then what is the point of any of these relationships? We are slaves. Not to have liberty is to live in a condition of slavery. And this kind of issues have today come up even in more developed countries. Now let's take the issue of people listening to the others, by way of maybe telephones, by way of inspecting the servers in the internet and various means. Today, any powerful government has the technological capacity to secretly listen. Now, is that lawful? Clearly, it is not lawful. It can be lawful if it is authorized by law, known to the people, for particular purposes. For example, if somebody is engaged in trying to throw bombs, in some places, in other words, to inspect crime, certain surveillance is allowed, but according to the law, according to the limits. Now, the accusation that has been brought even regarding United States is that they have given unlimited authority to spy on anybody. So the question of the legality and illegality is today even questioned even in developed countries. Is an issue of rule of law, whether that country, then the question is whether that country is governed by rule of law. That's the issue. If you don't say that it is not governed by the rule of law, you are virtually saying you do not respect the liberty. All these considerations are necessary because there is another way of ruling than the rule of law. And this way is called the law and order. The law and order methodology is that the government says, for the sake of order, I can do whatever, whether it is legal or illegal is irrelevant. I have the power because in the way I define order, I can do these things. So the complete arbitrariness and complete undoing of all rights is also in another philosophy. In Asia, we have a contest of two philosophies. Rule of law based system philosophy and the law and order based philosophy. And unfortunately, the predominant philosophy that is really applied in Asia in most countries is the law and order philosophy. So there is a fundamental debate in Asia whether there is a meaning of law, whether we have rights, whether we have protection, or are we the mere playthings of all powerful governments who can do whatever they like. Now that debate is the living debate of Asia today. Throughout the ages, the rules relating to the use of force have been defined. Of course, society being what it is, human beings being what they are, there is a evil side to us as much as there is a good side to us. And we need the protection from each other. That's a very unfortunate thing. The people need even the protection from each other because we can do harm to each other. For this purpose, the state has the right, the only, the depository of which has the legitimacy to use force. None of us have the right to use force. So, being the authority that has been given the right to use force, they are also limited strongly by the extent to which they are permitted to use force. So this, what is permissive and what is not permissive is central. So for the police, for the military, there are certain things which are permitted. For example, if the police is investigating into a crime and according to the basic rules, there is sufficient evidence gathered to show that I can implied in that crime, then they have a right to arrest me for investigation of that crime. And if I am found innocent, I should be released immediately. Otherwise, if a court punishes through the due process, then I could be, put in a prison or punished. Now, this is the only possibility for the police to use the power of arrest. You cannot say, well, I don't know, somebody has done something. I don't know who it is. Now I'll arrest you to find out and ask some questions whether you may be the one. And this is happening. Now that power is a power that they do not have. Secondly, that is, we say in the Civil and Political Rights Covenant, this is under the rights of security, the limitations on arrest and detention. Then there is a question of torture. Has the police or military any right to torture people? No, they don't have under any circumstances. So their power there is nil. That if they do, they are committing an offense and that should be punished. Again, there is the question of extrajudicial killings, which includes things like disappearances. Now, those are absolute rights. Right to life is absolute. There is no right for anybody except a court, after hearing a case, to give an verdict for death. Even that is challenged today, whether it should be a death sentence. But that's a separate issue. But if at all, it is only by a judgment of court after following due process that such a decision can be made. So, any form of extrajudicial killing is not power of the military, not within the power of military, the police or paramilitary or anybody. The same is regarding when they use powers, for example, to we talk about punishing people, the right of fair trial, that even a court cannot decide without a fair trial. Now, I mentioned to you yesterday the incident about this lady being deported. Now, there was no trial. That decision could have been arrived only through a trial where she could challenge. And not just a trial, Alice in the Wonderland, type of, any kind of trial. It has to be a fair trial, and fair trial has principles. Person must be charged, the charges must be given to him, there must be a right of a lawyer to represent them, and there is a right to cross-examine any of the evidence given. All evidence must be given in an open court, all should be on record, and finally a judge should make a decision only on the basis of evidence and nothing else. And what is evidence is only again defined by law. So a lot of limitations are being put to the use of any authority. So this applies also when you make decisions, for example, regarding, let us say, publication, whether there is a right for state to put any kind of censorship, any kind of limitation on publications or, expression of opinion, which are fundamental rights. They are only very limited scope, where, for example, there is defamation or there is an attempt to incite people into violence or to do a crime or something like that. So when a limited scope, they could make some of these limitations, but they are limited. So that whether it be the police, the military, paramilitary, or courts, or anybody, that they exercise only limited power, circumscribed by the law. These are fundamentals. And where you violate that, you violate human liberty, and they are illegal and deserves to be punished. See, no culture can stand against liberty. There are specific cultural things. For example, in a particular culture, the way you would declare your marriage, in public, somebody may be in a church, somebody it may be on a ceremony, and if they do wish to follow that custom, well, those are just customs. The culture cannot override liberty. And the culture was not meant to override liberty. And what is the culture involved in overriding liberty? Is the absence of culture. Is going into barbarism. So cultures are very important. Cultures have many important things, but culture protects liberty. Culture does not destroy liberty. So no culture will come an object to law, because the law merely put down the civilized behavior on how to do things. In other words, nobody should be harmed except where he has done some wrong in the proper procedure. So cultures is wrongly interpreted. Now, for example, the way this lady was deported from Sri Lanka was on the basis of a cultural argument. that if a person sees that she wears a tattoo, they may see the things that it is an insult to their religion. How that anybody could have imagined that is beyond anybody's understanding. This lady, obviously a very deep devotee of Buddha, has a beautiful picture, which inspire respect, not any kind of. But anyway, now there's a culture using as a pretext, and that's the very opposite of culture. To say that, oh, according to our culture, you can kill a person, that is, the in barbaric circumstances there were such things. But we have, that is why law is brought. The very idea of the law is it puts a limitation to anything. Even if there was a cultural habit in the past due to, certain circumstances under which the people lived, in the present circumstances, in terms of our understanding of what is harm and not harming others, anything that harms, even if it is legitimate by culture, is wrong. Yeah, there also, this is the same principle which we describe. The state, as the bearer of use of force, has the right to prevent civil unrest, use of violence of people by each other, even leading into civil wars and various things. These are all happens in, we know by history. Then there is a very strict limitation under Article 4 of the civil and political rights. That, first of all, you can use extraordinary measures only by declaring that a situation of emergency exists. So if there is such a civil commotion, the government must declare, of course there will be rules of how you declare, say that now there is a state of emergency because of these particular circumstances. So people should know there is this situation. Then they say we are authorizing our authorities, police and military, to do certain things under these circumstances. And that must be necessary measures. Who decides whether it is necessary finally? By a court, it can be decided. That there are many instances where court has said, no, this is not a necessary limitation. So you cannot just say, shoot at sight. Unless it is such a commotion that all possible warnings and everything has been done. It's rarest situation. It's very unlikely situation. So by if it is followed, it will be reasonable use to the extent necessary. Which means that the moment that necessity passes away, that law also should pass away. So immediately should be declared that emergency is now over, normal law prevails. We have all the right to live under normal law unless some extraordinary circumstance. It need not be only civil war situations like that, some natural disaster, which has threatened the life of people. But that is objectively determined. That you must be say, is there some real problem? If that is there, then to a limited extent, there is the possibility, and it should remain only limited periods publicly declared. Because if they don't understand that, they are losing the very meaning of their mandate, which is to defend liberty. See, these days there are these terms like human rights defender and all this. See, we are defenders of human liberty. Human rights arises from human liberty. And it is the duty of everybody, for the sake of his own survival, his own rights, to defend liberty. And if we give up in any of these areas, we are giving up liberty. And then what are we? And that is why we should always go back to past and see with how great difficulty these liberties have been won. People have been slaves. Slavery had been there everywhere, not only in United States and Rome. In Asia, many of the countries there had been severe forms of slavery. There had been things like untouchability and caste. There have been so many oppressive kings and the rulers, and barbarity of which is undescribable. Because we have not described it openly, people take only examples from the West. But here in Asia, we have seen the worst. We have seen the cultural revolution in China. We have seen the starvation deaths in China, for example, where 30 million people over that light. We have seen Cambodia. We have seen Suharto's Indonesia. We have seen military regimes. All these things, are moments at which our liberties were taken away. So liberty is as important to a human being as breathing fresh air. As much as we should defend our right to live in an unpolluted world, we have to defend our right to live free, so that as much as me, the people around me also lives free. What is happiness without freedom? What is happiness without liberty?